Do Palestinians have a legal right to resist occupation? The answer to this question has huge implications for ordinary people living in and outside of occupied territories, politicians from the global north and south, police leaders and prosecutors, human rights campaigners, faith leaders, and just about anyone who has an interest in the Palestinian cause, justice, and enduring peace in the region. The short answer to this question is yes, with two very important and big qualifications and limitations. So please watch this post to the very end. The general right of Palestinians to resist their occupation is in fact part of international and customary law. In 1974, the non-legally binding resolution 3314 of the United Nations General Assembly was passed and reflected customary international law. This resolution prohibited states from any military occupation, however temporary. This resolution not only went on to affirm the right to self-determination, freedom, and independence of peoples forcibly deprived of that right, particularly peoples under colonial and racist regimes or other forms of alien domination, but also noted that the right of the occupied to struggle and to seek and receive support in that effort. This resolution had in mind different people across the world, including people subject to South Africa's then apartheid regime, and also Palestinians living under Israeli occupation. Now, the term struggle was notably left undefined in the 1974 resolution, but was then further clarified in explicit terms in the 1982 resolution to mean armed struggle. This 1982 United Nations General Assembly resolution, again a non-legally binding resolution, but again reflected customary international law, reaffirmed the inalienable right of the Palestinian people and stated the legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle. This right of Palestinians to resist occupation is also recognized by international humanitarian law, also known as the laws of war. Amendments to the Fourth Geneva Convention under Protocol 1, 1977, explicitly affirmed the right to use force in situations, that is, armed conflicts, in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination, as enshrined in the Charter of the United Nations and the Declaration on the Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. There are also regional treaties, such as the 1998 Arab Convention for the Suppression of Terrorism, which specifically excludes as an offence all cases of struggle by whatever means, including armed struggle against foreign occupation and aggression for liberation and self-determination in accordance with the principles of international law, shall not be regarded as an offence. A clear nod to the Palestinians' right to resist their foreign occupation. But there are two very big qualifications which place two very big limits to the exercise of Palestinians' right to resist occupation. The first limitation to the Palestinians' right to resist occupation is that any act of armed struggle must be in accordance with international humanitarian law, the laws of war, specifically but not limited to the principles of distinction, that is, to distinguish between occupying combatants and civilians. This means indiscriminate firing of rockets or killing or taking civilian hostages are prohibited by international humanitarian law and would amount to, at the very least, a war crime. Now, the second qualification, and again a big limit to the Palestinians' right to resist occupation, may be based on national laws of a particular state. Under national jurisdictions, some states have prescribed or banned a particular Palestinian group or groups. So, for example, in the UK, both the military and the political wing of Hamas have been prescribed or banned. Therefore, in the UK context, while there exists a general legal right to support Palestinian resistance to occupation according to both international and customary law, as mentioned, and therefore applies to the UK, assuming the UK state is abiding by international legal frameworks and the international rules-based order. But specific support for Hamas in the UK would not be legal, and in fact would amount to a very serious terrorist offence, subject to a maximum sentence of 14 years in prison. What further complicates matters is the lack of legal clarity provided by political and police leaders, especially in the global north. It is noticeable during the past 30 years, in heightened periods of conflict between Israelis and Palestinians, many global north politicians continuously and openly promote and support Israel's general right to use force, usually couched in terms of Israel's right to self-defense when Israelis are killed, threatened, and taken, but remain completely silent about what international law says and what their own national laws say about the Palestinians' general right to resist occupation and defend themselves in occupied territories when Palestinians are killed, threatened, and taken. Why the inconsistent approach by some leading political figures in the global north? Well, you tell me. Feel free to comment, subscribe, follow, like, and share.